Yes, well, yes, but you're not exempt from treating someone who is imprisoned in compliance with their charter rights. So I don't know how far back you want me to go, or if you want me to start talking about the issues. Do you want me to talk about the case or the issues?
Um, the case, yeah, let's start with the case.
Okay, so what happened is, is it Gautier?
Gautier, yes.
Gautier. Okay, Gautier appeared in bail court on December 13th, 2024, and then refused to be brought to court again on December 16th, the 17th, the 18th, the 19th, the 23rd, and then January 22nd. So then the Crown applied for an order pursuant to Section 527 of the Criminal Code to have him forced to attend court. And so he ultimately ended up going to court, so he didn't have to worry about being forced, but which was on April 4th. But what the judge did is he kind of created like a study to find out if it is an infringement on someone's charter rights, where the issues if you force somebody to go to court. And so what they did in that situation was they had the an amicus and the superintendent participate in a study and provide their opinions. And the judge concluded that Section 527 of the Criminal Code intersects with Section 25. And when you read both together, it says that once the court makes an order for someone who is imprisoned to attend court, you must, and they refuse to leave, um, they refuse to leave jail and appear, that there could be reasonable use of force to get that person to appear. And so the court said in that situation that it's not really up to the prisoner to say no, because what they did, the practice at that time was the prisoner would be asked to attend twice. And if the prisoner said no, they would just leave it alone. So the court said it's not up to the prisoner to decide whether or not he or she will appear. Neither is it up to the person who's going to bring them to court. It's a court order and you have to comply. And the court order is actually, if you don't comply, then you can be held in contempt of court and imprisoned. So that's what the court ultimately decided, that it's not an infringement of someone's charter rights as long as the force is reasonable. If you go beyond reasonable force, then that could be an infringement of someone's charter rights.
Now you mentioned, yeah, the ruling says that reasonable force can be used to bring an accused to court. What does that imply? Are we talking shackles or other constraints or?
I would think that, to me, the implication to me is it depends on the situation. So if someone is refusing to stand up, you might have to use force to get them to stand up and walk. If someone refuses to walk, you might have to use force to maybe to transport them over. So it just depends on the resistance. And then the force has to kind of be aligned with the resistance. You can't have someone, to me, say, I'm not going to go, but they stand up to go, and then you push them to go because they're already starting to go. So I just think it has to be in proportionate to what the person in prison is doing.
Now, more broadly speaking, is there a valid argument why an accused would refuse to attend court? Do they ever have the right to say, no, I'm not going to go?
Well, according to this section, no, they don't have the right to say I'm not going to go. Once the court orders for them to appear, then they don't have the right to say no. So I don't know what the valid arguments would be to say doesn't want to go. I could see if the person is very sick, if the person is unable to walk, mental health issues, but I can't see that being the norm. Once you
Can a
say,
tr
sorry.
Sorry, can a trial or a hearing proceed without the accused being present?
Yes, a trial can proceed, um, but there might be circumstances where the accused is required to attend, say, compelled to be a witness. If there's perhaps maybe a sentencing hearing, then it's usual that the person has to be there, or even like a contempt hearing. So usually you would have the accused there.
What are the implications of allowing an accused to refuse to attend court? Is it mainly wasting court time and other resources? Is that the main concern?
Well, it's causing delay because once the accused doesn't attend, then that proceeding may not be able to proceed, and then you have to reschedule it. And because we are backlogged in our system, we can't really afford further backlog. So that's one implication. Another implication is if in terms of sentencing, usually the victim's family has the right to confront the accused, and that takes away their right. So I can see that there are some implications for our Canadian society when someone does not show up to court when they need to.
Okay, that's all the questions I had. Was there anything else that you wanted to mention or to comment on this before we wrap up?
Yes, I focused more on what you asked me to, which is what are the problems with this? I don't know if you want me to speak about
Yeah,
it.
absolutely. Yeah.
There are quite a few problems. So I narrowed it down to about 7. And
Okay.
so the first problem is that this like the judge cited that part of the reason why you would compel somebody to attend court is because rescheduling hearings causes delays. And so enforcing this section of the criminal code, these 2 sections, may cause further delays because use of force may lead to further altercations, right? And so correction officers may be assaulted when they compel one to attend court, which may cause more cases in the system, which is already overwhelmed with work. And it was actually cited in that judge's decision, paragraph 34, R in Jackson, where it wasn't the exact same type of order, but it was an order to compel someone to attend pursuant to a warrant. And that corrections officer was assaulted, and that person who was then charged with assaulting a corrections officer was found not responsible or not guilty because the court said the Crown did not discharge its burden of proof. So you're looking at trying to reduce delays, but if the accused assaults someone and then is charged with that assault, that's more cases in the system, and that could cause more delays.
Okay.
A second issue is that correction officers that don't compel one to attend court may be held in contempt. I don't think we really want our corrections officers who are doing like a great job to be in jail. That's not going to help our system unclog the delays. It might cause further delays. So I think that could be a potential problem. Another thing is excessive use of force may be in breach of Charter Values, Section 7, which is because, and also excessive is also subjective, which also I think you were trying to allude to.
Yeah.
My fourth point is it might not make sense to do this because in a situation where someone is forced to attend court to be a witness, you can't force that person to speak. So you might go through the process of trying, like getting an order for this person to attend court, the person attends and just refuses to participate. There's not much you can do at that point in time, but you've used resources to get that order. One thing that was interesting to me is that it didn't consider the use of technology, which I thought would be prudent. As a lawyer, when I participate in Zoom court, it's still court. I still have to be robed. I still have to observe all the court's rules. So it's still very formal. And so I was thinking when I read this, if an accused refuses, or someone who's imprisoned refuses to attend court, why not bring a camera and a TV to their cell, turn it on, and see if they'll participate? Then you don't need anyone to really touch anyone or to force anyone, and you can see whether or not this person will participate. And in England and Wales, I was reading about this because this happened there a few years ago for the discussion of making someone attend court. They found that sometimes when you force someone to attend court, they can sometimes act pretty disruptive. So there were situations of spitting, biting people, fighting, turning back to the court, abusive to the court. So that could be counterproductive if you force someone to attend and they're so disruptive, you're going to waste time anyway, and it's not going to be productive. And especially if it's a situation where you're facing the victim's family, that's not going to help the victim's family feel any better if someone is disrespectful, in my view, to the court. My last point is, like I'm a lawyer and a lot of us have knowledge of our charter rights. you have the right not to incriminate yourself, right? That's your charter right.
Mhm.
And it's 4B. And so if you are forced to attend court, you may not understand that you don't need to testify in your own hearing. So you might inadvertently incriminate yourself, which infringes against your charter rights, because you think, okay, well, someone's forcing me to attend court. I don't want to attend court. I must have to say something. And you might testify and without knowing that you don't have to do that. So there are a few problems. And my recommendation is that technology be considered to alleviate this concern. And I think if technology is considered for one who refuses to leave the jail cell, that will reduce abuse, because if a person's abusive, they could just turn it off. That will reduce chances of touching someone. And then there won't be an argument about reasonable or unreasonable force. And also correction officers may not have to worry as much about going to jail versus perhaps being assaulted. So I think technology is something that really should be considered, because the criminal code was written a very long time ago. And I assume it was before we had video conferencing available. And now that we've advanced, especially because of COVID, why not use that to our advantage to help reduce delays?
Okay, and just as a follow-up, did you happen to come across other jurisdictions that face this problem and come up with other solutions?
Not other solutions. I just saw a lot of complaints. So I saw in England and Wales, that's what I was
Okay.
trying to do some research. Just they're saying that the spitting and biting was starting to be a problem. And it was kind of productive to make someone attend if someone acts in an abusive manner. But I didn't see too many. The only solution was don't force anyone to attend court, but I didn't see any workaround. The technology idea is something I just came up with on my own, because that's what we do as lawyers, and it makes things much more efficient. And if there's a self-represented in Zoom court who is warned and doesn't behave, the judge may put that person on mute. And that helps the court process be less disruptive.